We're not lawyers.
The Constitution of Australia.
The law!
As far as the world knows, you're a goddamn lawyer, and that's the way it's gonna stay.
There is no one section. It's just the vibe of the thing.
Boom! Lawyer. This is Democracy Manifest.
Good evening, Brisbane, and welcome to A Current Law, where we discuss all things related to or affected by the legal system here in Queensland. As always, I'm your host, Samuel Whitelaw. Now, as our avid and dedicated viewers may know, over the past few weeks we've focused on tort law, in particular negligence. Well, tonight is no different. Let's have a look at this week's issue. Well, there you have it. What an introduction to an increasingly prevalent and difficult issue in today's society. Now, before we discuss it any further, I'd be remiss not to introduce tonight's special guest, Usman Khan. Usman, welcome to the show.
Thank you for having me. I watch the show regularly, so happy to be here.
Oh, wonderful news. Well, it's great to meet a fan of the show. Now, Usman, you're currently the president of the IPCPA. What is the IPCPA?
Yes, of course, the IPCPA is an interest group I founded a few years ago. It stands for the Injured Pub and Club Patrons Association.
Very interesting. Well, obviously being the founder of an interest group, it's a pretty big deal. Would you be able to tell us about how all this started?
Of course, a few years ago, my father was in a Brisbane pub. He had too many drinks and stumbled out of the pub onto the outside road. Anyway, he was apparently vomiting outside the pub, and after a while he passed out, and unfortunately happened to be laying in a way where his airways were obstructed, and unfortunately he passed away.
I'm so sorry to hear that. That sounds absolutely horrible.
Yeah, it was pretty rough on the family, so I took some time off to get my head right. Anyway, to gain some clarity on what had happened that night, I was able to view the CCTV footage, and I was shocked to see that the whole time he was vomiting and stumbling around, and even though he wasn't in the pub, the 4 custodians, they had a full view of what was happening at the time. And I asked them that why didn't they do anything, and they simply told me that he was drunk, people get drunk and vomit outside all the time. At that point, I knew that I had to do something about this. If it's happened to me, it's happened to someone else as well. So I began researching for myself the laws around state of liability with regards to whether the custodians owe a duty of care towards intoxicated patrons, and I found huge flaws, not in only Queensland's legislation, but also flaws throughout Australia.
Wow. So what did you do from that point?
Well, after noticing that, I put my feelers out on social media, asking if anyone else was interested in this area of law, and the results were phenomenal. I met up with a few of them that had reached out to me, who had also researched, or who had also had some legal background, and we decided to start an interest group, which is now the IPCPA. We now have 500 members all over Queensland. I spend a majority of time leading the interest group and putting pressure on our politicians to get justified law reform.
Sounds like an absolutely awesome cause. Now, who from the IPCPA have you brought along with you today?
I brought my dear friend and lawyer, Michael Ross, who is IPCPA's number one when it comes to the nuts and bolts of the law. And I've also brought with me another dear friend, Harvey Spector, a former lawyer and now sociologist, who does a lot of work with us at the IPCPA.
Fantastic. Well, how about we get Michael to give us a quick rundown of the state of liability and how it currently stands in Queensland, before Harvey can dive into greater social and policy effects. Then maybe you and I can have a quick discussion a bit later about possibly some future reforms. How does that sound?
Sounds good to me.
Awesome. Well, across to you, Michael. The IPCPA's central argument is that the law relating to negligence in Queensland, in particular the liability of pubs and clubs and the duty of care they owe, does not adequately serve the needs of their patrons and in turn society in general.
Thanks so much for having me on the show tonight, Sam. So basically in Queensland, there is no recognised duty of care owed by a licensed premises, which includes clubs and pubs, towards intoxicated patrons, as per Section 46, subsection 2 of the 2003 Queensland Civil Liability Act. Subsection 1 states that just because a person may be intoxicated, it does not require an additional or increased duty of care on behalf of the person who is dealing with them. It's pretty much saying that as long as a club has fulfilled its regular duties of care towards its customers, they don't need to worry about anything else. Mainly in cases where there is a question of intoxication, the Civil Liability Act cites this as contributory negligence, as per Section 47, subsection 1 and 2. For example, if there was an intoxicated patron and he left the club and he got involved in an accident, then that would be considered as the plaintiff's contributory negligence. The only way this can be rebutted is under Section 47, subsection 4. That is, if the plaintiff can show that the intoxication didn't contribute to the breach of duty. That is, even if the plaintiff wasn't intoxicated, injury or death would still have happened. In most cases of contributory negligence, damages are still awarded, but to a lesser extent. However, as no duty of care falls on clubs or pubs towards an intoxicated patron, there hasn't been a case where a person has successfully sued for negligence. There are two major cases on this issue. Both cases arose prior to the introduction of the Civil Liability Acts, and thus do not use those acts as a source of judgment. But the important point to note is that in both cases, similar judgments would have been passed and would have been made had they been decided in lieu of the acts, because the reasoning was consistent with the legislation we have today. The first case was the 2004 case of Cole and South Tweed Heads Rugby Club Limited. In Cole, the plaintiff had attended the club at about 10 o'clock in the morning, and by 3 o'clock she was severely intoxicated. The club just after 5:30 told her to leave. A little while later, while she was making her way home, she was struck by a car and sustained serious injuries. Chief Justice Gleeson stated that a person understands the risk they take when becoming heavily intoxicated. It would become burdensome for the clubs if they had to manage that risk, because it is hard to say exactly when a person is heavily intoxicated. His Honour further said that if a person who was heavily intoxicated was to commit property damage at the club, they would still be liable for their action, and thus reaffirming that the criminal and civil law hold a person responsible for their actions. They shouldn't be able to avoid responsibility for the risks and personal choices they make when consuming alcohol. Justice Callanan added that the law should not recognise a duty of care to protect persons from harm caused by intoxication following a deliberate and voluntary decision on their part to drink in excess. Therefore, the High Court of Australia held that there was no duty of care owed by the club. The second case was the 2009 case of CAL number 14 Proprietary Limited and Motor Accidents Insurance Board. In CAL, the plaintiff had been drinking at a motor inn when he came to know that the police were doing breath tests nearby. The plaintiff decided to have his motorcycle locked away by the motor inn, and the licensee understood that the plaintiff's wife would pick him up. Eventually, the licensee asked the plaintiff to leave as he had enough to drink. The plaintiff repeatedly asked for the keys to his motorcycle, and eventually the licensee gave them to him. The plaintiff went on to have an accident while going home and unfortunately passed away. The High Court of Australia unanimously held that there was no duty of care owed by the licensee. Justices Gomeau, Hayden and Crennan stated in a joint judgment, persons in the position of the proprietor and the licensee, while bound by important statutory duties in relation to the service of alcohol and the conduct of the premises in which it is served, owe no general duty of care at common law to customers, which requires them to monitor and minimize the service of alcohol or to protect customers from the consequences of the alcohol they choose to consume. In addition to this, their honours mentioned that allowing a duty of care would refute personal autonomy. it would allow patrons to be detained which would mount to other breaches of law by the licensee. For example, not returning of the keys would have allowed the plaintiff to use force to obtain them. And if a duty of care was bestowed upon the club, then they would have committed false imprisonment or committed battery as well. As I said earlier, even though these cases were decided without the Civil Liability Acts we have throughout Australia today, the reasoning given goes hand in hand with the legislation of today. However, I want to go back to the Cole case and look at the dissenting arguments of Justices McHugh and Kirby, who stated that the licensee's duty extended to take reasonable care to prevent injury to those who had been consuming alcohol on the premises. In particular, Justice Kirby held that the personal autonomy was overshadowed by the fact that the licensee was making a profit from the alcohol it was selling. If a person makes a profit from a service provided, don't they ought to provide a duty of care to them as well, as a result of that service? If a person who has been operated on by a doctor, and he finds out later that the doctor was negligent in the operation, he will sue for damages. Then in my view, why can't the same situation be applied here, where sure, the patron has left the premises, but because of the service that was provided to him, which was the alcohol, why can't there be a duty of care owed by the licensee? Again, the doctor makes a profit from the operation, and the licensee makes a profit from selling alcohol. There is a Queensland case in which a judge held the opposite of what happened in CAL and Cole. That is, in the 1997 case of Johns and Cosgrove. The facts of the case are similar in that the plaintiff was heavily intoxicated, left the premises, and was involved in an accident. He had lost his balance and had fallen into the path of an oncoming car. Justice Darrington applied the principle from the Canadian 1973 case of Jordan House Limited and Minnow. It is not negligence merely to serve a person with liquor to the point of intoxication, but it is if, because of the circumstances, it is reasonably foreseeable that to do so would cause danger to the intoxicated party, such as, for example, where the intoxication is so gross as to cause incapacity for reasonable self-preservation when it is or should be known that he or she may move into a dangerous circumstance and where no action is taken to avert this. I want to emphasize on His Honour's words of intoxication is so gross as to cause incapacity for reasonable self-preservation. This is in stark contradiction to what their Honours held in Cole and CAL, where the consumption of alcohol was contributed to a person's personal choice, and therefore they are responsible for the consequences of what they do. The Johns case was thrown out on appeal due to unrelated reasons to the judgment, but what Justice Darrington has said is common sense. If one person has no ability to take care of themselves, and as a result of the alcohol you have given them, and the danger is reasonably foreseeable, then why would you not take measures to make sure they reach home safely? Even though in Australia, no duty of care is recognised on this issue, in Canada it is. In the Canadian 1980 case of Canada Trust Corporation and Porter, the court extended a broad duty of care, instead stating the hotel should have established safe practice by controlling the conduct in question, which was not to serve the patron beyond intoxication. Generally, Canadian courts have held licensees liable even if they had no knowledge of the person's intoxication, no prior dealing with them, or no knowledge of how vulnerable they could be to alcohol. This contradicts what Chief Justice Gleeson said in Cole, that clubs don't need to manage the risk patrons undertake when consuming alcohol. Canada has based their law on the ability of the licensee to be able to control the actions of patrons, which completely goes against the personal autonomy principle that was held in Cole and CAL. In fact, in CAL, Justices Gameau, Hayden, and Crennan specifically said that the Canadian approach should not be followed as it does not take into consideration legal incoherence. Queensland needs to have a look over its duty of care, as currently it is simply allowing licensees to make profit out of the intoxication of patrons without any care to how vulnerable they may be once they leave the premises. That's it from me. Back to you guys in the studio.
Thank you so much, Michael. Geez, he does know his stuff about the negligence in the CLA, doesn't he?
Yeah, he's very good at what he does. A fantastic asset to the IPCPA.
Of course. Now, Usman, being a fan of the show, I'm sure you're well aware this is not simply a show about the law. It's about anything related to or affected by the legal system here in Queensland. You mentioned your friend Harvey Specter, the sociologist, earlier. What role does he play? And why have a sociologist in an interest group that's focused purely on law reform?
I sure do. Harvey, like Mike, is a valuable asset to the IPCPA. Essentially, posing law reform is incredibly easy. Any piece of legislation can be reformed an unnumbered amount of times. But the trick is, for Parliament to even consider reforming the law, you need a strong case on why it needs to be amended. The evidence for most reform often doesn't even come from the research in the legal sphere. It comes from everywhere else, society as a whole. For example, I could propose to reform the criminal code. I could propose that we make stealing legal and completely remove Chapter 36. But why? Why is arguably the most important bit. Unless you have a strong why, proposing reform will never get through Parliament.
Geez, that's such a good point and very well put. I suppose the law affects us all, and anyone looking to change the law should have a pretty good case on how the changes will affect society as a whole.
Yeah, exactly. That's what Harvey does. He researches all the sources and collects a case of how our proposed reforms give custodians a greater duty of care and how it could affect society in general.
Well, what are we waiting for? I would absolutely love to hear what he has to say. Before he comes on though, I would like to encourage our viewers to put yourself in the shoes of the policymakers as you listen to the effects of these proposed reforms can have on society as a whole. What would you do? Do these laws need to be reformed? Have your say at #ACurrentLaw. The floor is yours, Harvey. Thank you so much for that glowing review, Usman. It's always good to hear the boss telling you how valuable you are. Now, I'd just like to further reiterate what you guys touched on in the studio. Any law or legislation is changeable or can be reformed, but why change law if it doesn't actually affect society or particular stakeholders within it? I hope my findings exhibit to those at home how this issue is greater than just the legal sphere and how the work of the IPCPA can affect more people than just those involved in the interest group. Anyway, something that transcends my arguments and is the logical starting point for discussing greater social and policy effects of the law of negligence surrounding the liability of pubs and clubs to their patrons is Australia's lengthy and well-entrenched relationship with alcohol, in particular its overconsumption. The conversation outlines that Australian consumption of alcohol began at an annual high point of 13.6 litres pure alcohol per head in the 1830s. It declined during the economic downturn in the 1890s before hitting a trough during the Great Depression for obvious reasons. There was then a long rise until the mid-70s before dropping slightly to 10 litres per head in 2008. Milton Lewis discusses in his book The Rum State that heavy drinking was an established cultural norm transported to Australia at the time of colonisation. Research, in particular a report done by the UK Institute of Alcohol Studies, pertains that at the time of Australian colonisation, the overconsumption of alcohol was well established in Europe, therefore its inevitable transfer to Australian society through early settlers makes logical sense. Over the past century, in particular from the 1970s onwards, advertising has not only been a catalyst for the overconsumption of alcohol, but has also helped fuel the fire of the Australian drinking culture. Good examples of this are evidenced in the Tui's and Victoria Bitter ad campaigns in the 70s and 80s. If we jump forward to 2016, the Australian Institute of Health and Welfare found that 1 in 6 Australians consume alcohol at levels placing them at a lifetime risk of disease or injury. 1 in 4 people have consumed alcohol at levels placing them at risk of harm on a single occasion, at least monthly. And 1 in 5 Australians aged 14 and over reported to being a victim of an alcohol-related incident. A Herald Sun article last year went as far to quote that it is well known that Australia has a drinking culture which runs through every aspect of our lives. To summarise, as I said before, societal evidence suggests that Australia's relationship with alcohol has been long, strong, and is now well entrenched. Furthermore, in the last decade, a trend known as binge drinking has also become very apparent. Health Director finds binge drinking as drinking a lot of alcohol in one session or continuously over a number of days or weeks. Reachout.com goes further and outlines that for men, it's 6 drinks in one sitting, and for women, it's 4 drinks in one sitting. All sources agree binge drinking can have a huge short and long-term negative effects. As discussed earlier, the Australian Institute of Health and Welfare found that 1 in 7 people have consumed 11 or more standard drinks at least once a month, and at least once a month in the past 12 months. So essentially, at least 1 in 7 Australians are binge drinking at least once a month. The previously mentioned Conversation article outlines that binge drinking is born out of an earlier 20th century practice in Australia known as work and bust, which is best exhibited today in practices like Mad Monday, where athletes excessively drink for days on end at the commencement of their season. As this excessive binge drinking culture developed over the years, so too did the industry supplying the means to do so. An Australian market research report done this year shows the industry booming. Pubs, bars and nightclubs across Australia create a combined revenue of $17 billion, comprising of over 6,000 businesses employing over 76,000 people. The industry has also seen a growth of 1.3% from 2013 to 2018 and shows no sign of slowing down. A relevant question that should now be raised is whether the booming industry is encouraging unhealthy behaviour. And my answer to that is of course it is. Business Insider Australia even headlined an article in 2012 that stated simply, advertising is encouraging binge drinking. Furthermore, an article by the US National Library of Medicine published a report that links the concept of happy hour, which is common practice amongst pubs and clubs all over Australia, to negative behaviours such as binge drinking. In 2012, the Australian Medical Association even published a report to encourage new public policy relating to advertising of alcohol to, among other things, lower the prevalence of youth binge drinking. So moving further, we now have two established things: a culture of people participating in unhealthy and dangerous habits, and an industry that is booming because of it. So theoretically, what should happen at this point is for policymakers and government to do what they are elected to do and curb behaviour, which the Australian government has attempted to do. Lockout laws were implemented in both Queensland and New South Wales in an effort to curb behaviour and mitigate harm. New South Wales went even further and banned shots. This push to regulate and reduce is a step in the right direction. But myself and the IPCPA pose that legislators need to incorporate a different angle of reasoning. Aforementioned research suggests that for now and the foreseeable future, Australian drinking culture, or Australians drinking excessively in pubs and clubs, is as inevitable as the sun coming up every morning. So rather than attempting to stop the inevitable, let's focus on protecting our citizens, who are essentially just themselves victims of the Australian culture. A helpful analogy is to think about seatbelts. Car crashes are inevitable, and whilst policymakers do put an effort into reducing the frequency of them occurring with speed limits and road rules, they also understand their inevitability and protect Australians accordingly. This is done in the form of regulating to ensure all new cars are manufactured with seatbelts and airbags. Regulations already in place to mitigating alcohol should be coupled with regulations extending the duty of care owed to pub and club patrons by custodians to ensure safety. I've noticed whilst working with the IPCPA that the notion of personal responsibility is often the most frequent rebuttal to our general vision. The argument of people taking the responsibility of their own drinking habits and dealing with the consequences is somewhat of a compelling one, I will admit. That being said, those making these arguments often, as the Bond Law Review puts, ignore the importance of hoteliers and custodians exercising at least some form of responsibility, which is incredibly dangerous. This essentially means that there is no requirement of personal responsibility on the part of those individuals that have the most to gain from the irresponsible conduct of others. Issues about the burden on commercial behaviour made in arguments of both Cole and CAL, mentioned by Michael, are based on the notion that pubs and clubs are busy establishments that serve important roles in Australian society. A society that we have already established has a lengthy and unhealthy relationship with alcohol and in turn pubs and clubs. The proposed extension of the duty of care would assumedly be enough to bother both patrons and custodians. I can agree to an extent, but I truly believe that desperate times call for desperate measures. And the Australian Department of Veteran Affairs found that alcohol is associated with 44% of fire injuries, 34% of falls and drowning, 30% of car accidents, 47% of assaults, 34% of homicides, and 16% of child abuse. With alcohol-related harm costing society over $15 billion in 2012, which included factors like crime and violence, treatment costs, productivity lost, and premature death. Combining this data from outside the law, I truly believe extending the liability of pub and club custodians toward their patrons is a small price to pay to at least somewhat curb the negative effects of alcohol and the resulting injury of its overconsumption on the Australian society. Thanks so much for hearing me out. back to you guys in the studio. So much, Harvey. What a fantastic presentation. Geez, that's some really in-depth and comprehensive research, isn't it?
Yeah, he knows his stuff.
He sure does. Now, before we go any further, we did ask the audience just to have their say earlier. Do you want to have a look at some of their responses?
Sure.
Sounds good. Okay, well, at GennaReasonable91 said, wow, what a great cause. I have seen so many really intoxicated people just get escorted out of venues before, and I always think more should be done to ensure their safety. Keep up the good work, guys.
Thanks so much, Jenna.
Jeez, that is pretty good. At Ange_Jaree62 said, this nation is getting so soft. I wish people would harden up and stop using the law to blame other people. If you drink, you should be able to deal with the consequences. Geez, that's a bit different. What do you think about that, Usman?
I see where they're coming from, but Harvey touched on this perfectly earlier. To use this logic is dangerous, as it ignores the fact that there is no requirement or personal responsibility on part of those individuals that have the most to gain from the irresponsible conduct of others.
And the irresponsible conduct of those with the most to gain, are the custodians and the hoteliers and the venue owners, aren't they? Yeah. Well, that's a very good point. And our last one is from at Matt_in_middle83. I see it from both points. I do think the idea of personal responsibility needs to be considered, but I do think you guys raised some fantastic points. Keep fighting the good fight.
Thank you, Matt.
Geez, well, thank you all for your intuitive feedback tonight. Now, Usman, throughout the presentation tonight, this idea and end goal of reform has been raised a variety of times. Can you shed any light on any specific law reform that the IPCPA is pushing towards?
Yeah, I can shed some light, but I cannot be as in-depth as I would have liked to have been.
What do you mean by that?
Well, actually, we have one of our best legal analysts currently focusing on specific law reform, and he could have given a more in-depth rundown, but unfortunately he was unable to make it tonight.
Oh, okay, I'm sorry to hear that, but I think a quick rundown for the viewers at home should suffice for tonight's purposes.
Of course. Well, initial law reform posed by the IPCPA is essentially encouraging the judiciary to take a different path with case law. I think the bond law review mentioned by both Harvey and Michael sums this up perfectly. It states, given the parallel intention of Parliament to minimise the excessive consumption of alcohol and the negative effects it has on society, it would appear prudent for the courts to assist in this approach by ensuring additional incentives are available for hoteliers to assist in curbing antisocial behaviour. Or as Michael discussed briefly, encouraging the judiciary to create an exception for custodians in the law of tort in areas like false imprisonment.
Do you think all sound very good and achievable arguments that you guys are raising? Usman, we're almost at the end of the show. Is there anything else you would like to say and tell the audience at home tonight?
I would just like to encourage everyone at home to get involved with the IPCPA. We're all over social media. You can swing us a message, or you can even come and see us. Action in this area is long overdue. The duty of care owed to pub and clubs patrons by custodians should be of much greater scope. I hope Michael, Harvey, and myself have exhibited that tonight.
Well, I for one certainly think you have. But anyway, that concludes this episode of A Current Law. Thank you so much to everyone at home for tuning in, and thank you to Usman and the IPCPA for coming on the show.
No worries.
Tune in next week for another hot button negligence-related issue that's affected by the legal system here in Queensland. This has been A Current Law. I'm your host, Samuel Whitelaw. Good night, Brisbane.